astonishing opportunity and event, and a real chance to come together to talk about our common values and values that are under threat. They were under threat in 2007. If you remember, that was during the Bush administration, and the war on terror and the attacks on international justice were ongoing. And today, of course, we have a situation in the world where we have aggression being perpetrated and terrible crimes around the planet. So Deputy Prosecutor Shamin is busier than ever. The ICC has more investigations going than it ever had. And so I think the opportunity to come to Chautauqua, to this beautiful place, both allowing us to fill our spiritual well, to talk about our common values, and to create an agenda for moving forward is really important. I'm reminded, listening to Ben, of the famous quote, right, that those who don't heed the lessons of history are doomed to repeat them. And I feel like we're slowly and inexorably sliding into a situation where we could be really facing a crisis. I hope not like he faced in his young life, but nonetheless, it is a scary time. And I think the importance of coming together this time cannot be overstated as we take up the charge, standing up to aggression from Nuremberg to Kyiv. At Nuremberg, the United States led the prosecution of the crime of aggression in the famous opening statement of Justice Jackson. We hear that. At Kampala, unfortunately, the United States was not leading the charge for the incorporation of aggression into the Rome Statute, but the opposite. So I think here perhaps we have an opportunity to reset that and rethink some of these relationships. As Jim said, I was here for the first dialogue in 2007, and it was extraordinary. We had Whitney Harris, we had Ben Ferencz, and we had Henry King. We had all three of them alive and with us, and now Ben remains with us, but far apart. And I want to give a shout out to a couple people who also are no longer with us. One is Sharif Bassiouni, and I'm not going to read from it because I don't have time, but his very last essay was published in this book on accountability for the unlawful use of force that I had the honor to edit, and that the Ferencz Foundation actually funded. And I really recommend the essays in here, including Sharif's, which talked about the political complacency and can we revive the crime of aggression. Another person that we lost just this year is a dear friend to many of us. Some will not know him, and his name was John Washburn. And John led the charge, if you like, for the Americans who supported the International Criminal Court. He founded AMIC, the American Coalition for the ICC. He led AMIC. He really started WIC, I think, the Washington Working Group as well. He single-handedly seemed to be the individual to whom we could all turn for information about the court, for lobbying about the court. There was a very small group of Americans who was supportive of the ICC during the negotiations, and again at Kampala, where he was there present for the negotiation. And I just wanted to read a poem in his honor. There will be a memorial service on the 17th of September in New York City. If you want to attend, Enid Adler and Jennifer Trahan, the lovely ladies sitting on the end of those rows with masks on, if you don't know them, can tell you more. But I want to read a little poem in his honor, which I think is fitting before I turn, of course, to the main event, which is introducing Ambassador von Schaack. And it's by one of my favorite authors, John O'Donohue, who is a great philosopher, priest, and I guess spirit conjurer almost. And the poem is called For Peace. As the fever of the day calms towards twilight, may all that is strained in us come to ease. We pray for all those who suffered violence today. May an unexpected serenity surprise them. For those who risk their lives each day for peace, may their hearts glimpse providence at the heart of history. That those who make riches from violence and war might hear in their dreams the cries of the lost. That we might see through our fear of each other a new vision to heal our fatal attraction to aggression. That those who enjoy the privilege of peace might not forget their tormented brothers and sisters, that the wolf might lie down with the lamb, that our swords be beaten into plowshares, and no hurt or harm be done anywhere along the holy mountain. Thank you, John. Rest well, dear friend. And if we could just have one moment of silence remembering his unbelievable contribution. Thank you. And now, turning really to the main event, it is my great honor to introduce somebody who really needs no introduction, but I'm going to introduce and embarrass you anyway. Ambassador Beth von Schaack is a shiro. She is a leader. She's an inspiration. She's been a friend and a colleague. She does yoga, which is really the best thing. And I remember seeing her in Kampala as the academic advisor to, I think, Ambassador Rapp, who then had her position. And just thought, how does she do it? Because she is an amazing human being. And in addition to all those qualities as an inspiration to all of us, she was sworn in as the Department of State's 6th Ambassador at Large for Global Criminal Justice on March 17th, 2022. She advises the United States Secretary of State and other members of the department on issues related to the prevention and response to atrocity crimes, including, of course, war crimes, crimes against humanity, and genocide, and hopefully aggression. Ambassador von Schaack served as deputy to the ambassador at large, as well as the academic advisor during Kampala. And prior to that, she was the Leah Kaplan visiting professor in human rights at Stanford Law School, where she taught international criminal law, human rights, human trafficking, and a policy lab. She has also been a practicing lawyer, as if that wasn't enough, at Morrison and Foster, the Center for Justice and Accountability, a human rights law firm, and served in the office of the prosecutor of the ICTY and the ICTR. She's published many, many articles, both on international justice and on human rights, that are extraordinary, both for the depth of the research and the quality of the writing. And her most recent dissertation, I guess, which was published as a book, Reimagining Justice for Syria, I recommend it really heartily. And there's a wonderful line in that book about water always finding its way as sort of an image to how justice will always find a way. And I think, Ambassador, you are the right person to lead us there. So please join me in giving a warm Chautauqua welcome to the United States Ambassador, Beth von Schaack. Thank you. Thank you.
Good morning, everyone. It's really a great honor to be here. I have been to most of these events, not all. I missed a few here and there when I had little kids and school was starting and this and that, but my heart was always here in spirit, and it's lovely to be here with my predecessor, number 4, my former boss, and a number of old friends with whom I've worked for many, many years in multiple different capacities. I was sworn in, as Layla said, in March of this year, and so very much as the Ukrainian war was ramping up, and I joined as deputy as the Syrian war was ramping up. So I'm hoping there's no causality in either of those two facts, but Syria overtook a great part of my time as ambassador, as the deputy to the ambassador, and now Ukraine as well. But I'm also very conscious of, as Secretary Blinken constantly says, the rest of the world. He wants us to be rowing. So we're all staying focused on the rest of the world. So I am trying to do that as ambassador at large as well, and I'll speak a bit about that. So today I've been asked to speak about the crime of aggression in the context of Russia's unprovoked war in Ukraine. It's brutal, it's unjust, it's generated horrific stories that we all, I know, are familiar with, and the world has never been more united around the imperative of justice. And so while we focus on Ukraine, we are all very hopeful that this is instantiating a recommitment to the Nuremberg principles more broadly. So this morning, allow me briefly to just recount a little bit about the history of the crime, which is a topic I wrote extensively on following from my role as academic advisor to the U.S. Delegation to Kampala. And I have previous experience having read many of the history of the crime going forward, so I'd love to share that with you today. And then I'll raise a few issues in connection with these proposals now to create a dedicated tribunal to the crime of aggression for Ukraine. And I hope that the group here of advocates and experts can consider these issues as they think about how to shape and push forward these proposals going forward, both in the next couple of days and then beyond. And I should note that my remarks are not at all the position of the US government. We're still exploring these various proposals, talking to friends, working with Ukraine, working with lawyers around the world who are representing this sort of analogies to the State Department, ministries of foreign affairs, et cetera, and also speaking with advocates and victims to see what is their vision of justice, what are their preferences for what should be, what sort of institutional response there should be when it comes to this brutal war. And so we know that any response should be informed by all of these different voices and stakeholders. So my remarks should be very much taken in the spirit of critical inquiry, of academic exploration, of creativity, of trying to think about the ideas that we have from the past and how we can shape them into a more peaceful and just future. So the idea of prosecuting those who engage in an unjust war has very long roots, as we know, going back to the works of Aquinas and even further, the idea of a just and an unjust war. But it was not until the post-World War II period that the idea that this might be criminal under international law was first explored. And the international community then committed to the idea of prosecuting the launching of an aggressive war, as a criminal act. In the lexicon of the era, this was called crimes against the peace, and within the Nuremberg indictment, it sat alongside war crimes and crimes against humanity, which was another innovation of the post-World War II period. But interestingly, it was the crime against the peace that was really the centerpiece of the Nuremberg proceedings, and not the crime of genocide. And Nuremberg, the trial, was meant to be the, quote, trial to end all wars. And this pride of place really reflected the reasoning of the Nuremberg Tribunal in the judgment that aggression was the proximate cause of all the other horrors that flowed from World War II. And quoting here, the judgment says, to initiate a war of aggression, therefore, is not only an international crime, it is the supreme international crime, differing only from the other war crimes in that it contains within itself the accumulated evil of the whole. And although the written judgment focused very much on the counts in the indictment dedicated to crimes against the peace and the conspiracy to commit crimes against the peace, it was very much the offense of crimes against humanity that I think in some respects proved to be the real legacy in some respects of Nuremberg, because it contributed to the whole human rights edifice that we now hold so dear, because it gave truth to the idea that international law spoke to the way in which governments treated their own citizens. It wasn't just how they treated the citizens of another nation, which is how war crimes had been defined at the time and how the crimes against the peace was conceptualized. It was the invasion by one state of the territorial integrity of another state. And crimes against humanity really made the point that actually what the Germans and the other Axis members did to their own citizens was also the subject of international law. And although the international community promulgated a treaty to ultimately criminalize the crime of genocide, which was a new concept that was born during the World War II period, neither crimes against humanity nor the crimes against the peace became the subject of a dedicated treaty. Layla is working very hard to rectify that latter problem, and she's making incredible strides in that regard. Now, before moving closer to the present, it's really worth noting that the then Soviet Union played a critical role in creating the Nuremberg edifice. It was jurists from the Soviet Union that conceptualized many of these core ideas and pushed them out, and they were ultimately adopted. And the work of Francine Hirsch, if you're familiar with her, she has a new book now and a couple of blog posts that really capture that deep history. And tragically, of course, President Putin has turned his back on that proud history and on Russia's international and domestic legal commitments, including under the UN Charter and the Geneva Conventions, which enjoy universal ratification. So defining and prosecuting a war of aggression, although not uncontroversial, did prove to be relatively easy following the complete defeat of the Axis nations in the World War II period, who had been responsible for unleashing war across Europe and the globe. However, when the international community eventually turned to creating what now would be known as the International Criminal Court, controversies emerged that stymied efforts to codify the crime for more general applicability in the future. As the Cold War set in, the International Law Commission, which was the body that was charged with codifying the results of Nuremberg, was the first entity to try and take on this challenge. And although elements of what would become the Rome Statute were decided by the ILC, they were unable to agree on a definition of aggression. This indecision ultimately delayed progress on the ICC project for many years, and this was very much a function of the fact that the Cold War had set in. Even as early as the Nuremberg tribunals, as that judgment judgment was being issued, already, and Francine really captures this in her book, these Cold War tensions are starting to set in, and the unity that had existed following World War II was starting to really crumble. Starting in 1967, it was the UN General Assembly that took up the task, and they tasked several committees to try and define the crime of aggression. This effort led to a consensus definition within General Assembly 3314 of 1974 that was not necessarily part of a penal code, but was rather meant to inform the Security Council in the way in which it would exercise its functions under the UN Charter to identify threats and breaches of international peace and security under Article 39 of the Charter. So after this period of Cold War quiescence sort of started to dissipate, the ICC idea was fully revived, and the ILC relaunched this project. States again sought to define the crime. And while influential, the definition of aggression within Resolution 3314 did not lend itself easily to a penal context. And so it wasn't clear whether that would be the core definition or whether they would go back to the Nuremberg era definition of crimes against the peace or come up with some sort of composite or new definition. And so other options were explored. A number of preparatory commissions, working groups, et cetera, were convened, including at Princeton University, discussing, really sort of evidencing the value of academic institutions in informing our work in this regard. And then finally, the 1998 Rome Conference, where the ICC statute was finally open for signature. Notwithstanding all of these years of effort, there was still a lack of consensus, and delegates representing the states of the world were unable to agree upon a definition of the crime or what the jurisdictional regime would look like that would govern the crime's prosecution. And so, in essence, all of us who were there will remember this well, we all punted, essentially. The crime of aggression was listed in Article 5, so it was clear that the court would someday have jurisdiction over the crime of aggression, but everything else was going to be delayed to a future review conference that was to be established within 7 years' time. And the only guidance that the drafters of the Rome Statute gave to their successors was a very cryptic declaration in Article 5.2 that said, eventually preconditions for the exercise of jurisdiction would be established that would be consistent with the UN Charter. So a series of preparatory commissions, special working groups, informal gatherings, et cetera, sorry, this is when the Princeton process happened, was after Rome, took up the task in the period up to this envisioned review conference, which ultimately was held in 2010 in Kampala. But even with all of that preparatory work, by the time we arrived at Kampala, a number of open issues were still in the text. There were these sort of square brackets around various alternative language that could have been chosen. The definition enjoyed a shaky consensus, but the jurisdictional regime was still subject to multiple options that were being debated. And a perennial difficulty here in trying to come up with both a definition and a jurisdictional regime was in terms of how definite aggression should be prosecuted, stemmed from the recognition of the fact that the crime, unlike some of the other crimes, really has as a predicate state action. Never did the delegates think about aggression as being committed by non-state actors. That just wasn't within the conception of delegates at the time. Now, maybe that was an error, and maybe we need to evolve our thinking in that regard when we think about organizations like IHLR, who were only just, a speck on the horizon at that point. But at the time, it was very much considered a crime of state. And so trying to recognize the principles of state sovereignty and how that would be transformed into a penal provision that would ultimately give rise to individual criminal responsibility proved to be tricky. Delegates also diverged on which body would be the determination of whether or not the state had committed this predicate act of aggression. And so there were questions about whether the Security Council, in its charter-based role, should take that on, whether the International Court of Justice, which has the ability to adjudicate state responsibility and had done so in the past with respect to violations of the UN Charter, or maybe even the court itself would be responsible for identifying this state act of aggression that would undergird the recognition of the commission of a crime of aggression. And because state action was so central to the conception at the time of aggression, delegates also raised the question of whether or not the consent of some state would need to be required in order to vest the court with jurisdiction. And so would it be the putative aggressor state, the putative victim state, some other combination of states, both states, would they have had to have consented to ICC jurisdiction before a prosecution could proceed? And so these two questions, the role of the Security Council and whether or not there should be some outside determination that an act of aggression had occurred, and whether or not state consent had happened, these were all present in Rome, but they came into much starker relief in Kampala. And to a certain extent, as the events within Kampala unfolded, and I know some of us here were there, it really was a story about jurisdiction and not about definition. The definition under Resolution 3314 ultimately held. States were unwilling to reopen that, and even with respect to the United States, which pushed to do so, we had absented ourselves from the negotiations up to that point, and it was only under the Obama administration that the United States began to re-engage with this process. The definition had a lot of momentum and staying power at that point, and so attention really turned to trying to establish the jurisdictional regimes that would govern the crime. The United States did, however, seek some understandings around the definition that raised the threshold for finding an act of aggression as a manifest violation of the Charter when it came to looking at the impact and effects of the crime. But also the understandings expressed a subtle preference that states not incorporate the crime of aggression into their domestic codes. And so this threatened to or suggested a way that complementarity might work differently when it came to the crime of aggression, as it does with respect to other crimes, where it is somewhat expected that states that join the ICC statute will incorporate the crimes into their domestic code and will then be able to prosecute domestically. And it's only when a domestic state with jurisdiction fails to move forward, is either unwilling or unable to do so, that the ICC would then step in. And otherwise it should be staying its hand and allowing the domestic court to deal with it. So essentially, the substantive outcome when it came to Kampala, two major decisions were made. Number one, and these both really reflected this idea of state consent. Number one is states parties were entitled to opt out of the aggression regime. There had been an opt-out when it came to war crimes under the original Rome statute. It was a temporary opt-out that now has been removed, but they borrowed that same idea. This is a permanent opt-out, potentially, that states could then, of course, reverse, but the idea is that states could opt themselves out of jurisdiction if and when they either ratify the statute or when they ratify the amendments. And also we saw the complete exclusion of the nationals of non-states parties. So in other words, states that have not ratified the treaty at all are entirely excluded from an aggression prosecution. And this is why we are at this fundamental point where Russian citizens who are the architects of the acts of aggression within Ukraine cannot be prosecuted by the court itself. Once the amendments entered into force, many wondered whether adding the crime had been a purely symbolic exercise. Was this sort of completing unfinished business from the World War II era, or whether the crime of aggression would actually be prosecuted going forward? And there has been a slow but inexorable ratification of these new amendments, and so now there's at least about a third or so of the states parties to the Rome Statute have ultimately ratified the new amendments. So it was against this legal backdrop that Russia relaunched its brutal and unprovoked invasion of Ukraine on February 24th, 2022. This is a day that, of course, will live in infamy. And unlike other contemporary conflicts that we have seen, this conflict really mirrors the archetypal international armed conflict from the World War II era. We don't see the complications associated with modern coalition warfare, with a splintered opposition, with the participation of transnational terrorist organizations, as we've seen in Syria and elsewhere. We do, however, have the operation of private military contractors, which is an interesting new factor that does sort of, in some respects, complicate the classification and the consideration of this conflict. Now, 6 months following the full-scale invasion of Ukraine, the war itself continues to impose mounting costs on Ukraine, but also on the globe. So thousands of civilians killed or wounded, 13 million Ukrainians forced to flee their homes, historic cities literally pounded into rubble, food shortages and skyrocketing prices around the world, all because Putin was determined to conquer another country. We know, and it is by all accounts, a manifest violation of the UN Charter, and the international community has repeatedly condemned the flagrant disregard for international peace and security. This war has also been accompanied by systemic war crimes committed in every region in which Russia's forces have been deployed. and this horrifying litany of atrocities continues to grow. Some of the early accounts discussed indiscriminate and disproportionate attacks upon civilians and elements of the civilian infrastructure, including hitting densely populated cities, residential areas, schools, theaters, precious Ukrainian cultural property, transportation hubs that are being used for evacuations, causing thousands of civilian deaths and injuries. These are crimes enumerated in the Venerable Hague Conventions of the World War I period, but also Additional Protocol 1, which is binding on Russia. Once areas were liberated from Russia's grasp, we saw war crimes of a different order. This was individuals with their hands tied behind their back, executed at the backs of their heads, reports of detainee abuse and mutilation, including potentially a castration of a Ukrainian POW, rampant sexual violence of women, girls, children, and even men, growing body of credible evidence that Russia's forces are torturing and summarily executing prisoners of war, military personnel, including non-combatants. All of these acts are prohibited by the Geneva Conventions, which now enjoy, as I mentioned, universal ratification and are also subject to customary international law. We've also seen Russia construct, and in fact there is now evidence indicating that much of this was in train prior to the launch of the invasion in February, a transnational infrastructure of filtration that enables individuals to be brought from Ukraine, subjected to interrogation and often abuse, either released if they're not deemed to be threats to Russia, or potentially deported inside of Russia and held in situations that are unknown to us at the moment because of the black box that is Russia. Our ODNI, our intelligence community, and also Secretary Blinken have both released statements that suggest that between 900 and 1.6 million Ukrainians, including 260,000 children, have been subjected to some sort of a filtration process or have been brought out of Ukraine and into Russia. And as we know, the unlawful transfer and deportation of protected persons is a grave breach of the Geneva Conventions and thus a war crime. Following a careful review of all of the information that was being generated in the early days of the war, the United States assessed formally that members of Russia's forces were committing war crimes under international law in Ukraine. This was announced in a statement by Secretary Blinken, and then I was asked on my second day in the job to take the podium and to take questions from the press corps about this to expound upon this assessment. And that's when I knew that the word I'm looking for, I shouldn't say in an open mic, but stuff had gotten real with this job. We also have information, just to round things out, that Russian Federation officials are working very hard to cover up evidence of war crimes, including the death of detainees, likely as a result of violent interrogation methods. All of this information reveals images, videos, reports, NGOs, victims' testimony, et cetera, witness accounts, that the atrocities are not the result of a few rogue units operating within Ukraine, but rather they are part of a deeply disturbing pattern of abuse across all areas where we see Russia's forces engaged. And they're also consistent with what we have seen Russia's forces do in past conflicts in Chechnya, in Syria, in Georgia. So, the accountability agenda. The international community, with, I'm proud to say, strong leadership from the United States, Canada, other states that are represented here, has swiftly activated a range of accountability mechanisms as part of a global, now an increasingly integrated system of international justice. Diplomatically, financially, and or operationally, the United States is supporting all existing efforts to investigate and report on atrocities. Now, this includes investigations at the ICC, which follows a massive collective state referral, evidencing real faith in the role that the ICC can play with respect to this matter. The establishment of a UN Commission of Inquiry with Judge Eric Mose, a former judge amongst our tribunals, as chair. The OSCE's Moscow mechanism, which is a rapid reaction investigative mechanism. The UN Human Rights Monitoring Mission that had been in place prior to the war, but now is continuing its work and has received additional funding from the United States and other states. A new joint investigative team that was initiated by Ukraine, a number of European states, and now the OTP, the Office of the Prosecutor of the ICC, has joined. And we've also welcomed proceedings before the International Court of Justice and are tracking cases before the European Court of Human Rights. There's also more to report on. The Eurojust has recently amended its regulations to allow Eurojust, which was supposed to be a sort of coordination mechanism, to actually serve as a repository of evidence that member states and others can draw upon in their prosecutions in their domestic courts. At least 14 states, and my number may be out of date at this point, and growing, have opened investigations, including what are now called structural investigations, to sort of look at the conflict as a whole and be ready if and when an individual over whom the court in that system has jurisdiction can immediately activate. This also evidences a deepening of state practice around the principle of universal jurisdiction. There's also work within our own system to think about how we can amend our laws to make them more part of an international system of justice. We've also seen Ukraine's very adept use of all legal fora that are available to it, including 2 cases at the ICJ under the Convention on the Elimination of All Forms of Racial Discrimination and the Convention on Terrorist Financing that predate the war, and a new one now under the Genocide Convention, which a number of states are now intervening in. And then, of course, the European Court of Human Rights. All of this plus really active documentation exercises by civil society, including the Ukrainian Bar Association, but other civil society organizations. And we're now seeing that Ukraine may overtake Syria as the most documented crime base ever in human history. In July, the United States helped to put in motion and then co-sponsored a Ukraine Accountability Conference that was in some respects modeled upon the London Conference. The idea was to get the international community together to commit to the imperative of justice and accountability for this conflict. The international community reinforced efforts. Representatives from 45 countries signed a political declaration condemning the acts of aggression and other war crimes and atrocities committed in Ukraine. And it notes that Russia has blatantly violated the UN Charter, threatening international peace and security, damaging the international rules-based order, and undermining democratic values. The main project that I've been involved in this constellation of efforts has been the Atrocity Crimes Advisory Group. This is a joint project with the UK and the EU to help support the Office of the Prosecutor General in Ukraine in their effort to prosecute war crimes cases. As the legally constituted entity with jurisdiction over everything happening on Ukrainian territory, this is a massive challenge, as you can imagine. These are prosecutors that have never potentially prosecuted a war crime before. Suddenly their entire territory is a crime scene that needs to be analyzed, evaluated, information collected, trauma-informed techniques being employed with respect to witnesses and survivors of this. The ACA is surging experts from veterans from the world's war crimes tribunals represented here to help assist the Prosecutor General, either in prosecution support units within Kyiv or in mobile justice teams that are traveling out into the field. So after the shopping center was hit, if you remember, there was a mobile justice team there immediately working side by side with their counterparts within the Ukrainian system. The hope of the ACA is that international donors who are trying to advance accountability can be better coordinated in their activities. So we're not over-investing in some lines of effort and under-investing in others. And it's never really been done before, this degree of coordination. So we're in somewhat of an experimental stage, but the hope is that we will be deploying our resources widely, avoiding duplication of efforts, and then ultimately recruiting the best experts in the world to assist with this effort. So it's in many respects complementarity in action. And as you may have read, the Prosecutor General has identified thousands of potential war crimes. There is a database of this, and so the ACA is helping to work with prosecutors to prioritize which ones of these incidents to pursue, because even with the most vigorous effort, it will be impossible, I think, to prosecute everything in the domestic courts. It's just an overwhelming task. And so determining which cases have the most evidence, maybe will set the most important precedent, is going to be a key challenge going forward. So given all of these efforts, there are another set of efforts that are underway that are supporting this accountability architecture. Not necessarily accountability per se in some respects, but in many respects we hope that it will continue to contribute to accountability efforts. So number one, imposing costs on malign actors. So the United States and other states, both individually and collectively, have imposed massive sanctions on Russian actors, both private and public. In the United States, most uniquely, we have sanctioned a number of members of Russia's military. That is not something that we have done in the past, and we're talking thousands of individuals at this point, so that is a new development. We have steadily declassified information at a much faster pace than we've ever been able to do in the past in order to inform the world of Russian actions and make information available for prosecutors going forward. The State Department, my sibling bureau, the Conflict and Stabilization Office, has established a conflict observatory that is doing open source evaluation, often of information that is behind a paywall, so for example, very high quality satellite information, but scrubbing social media feeds and the whole range of open source information we have, and producing really refined reports. So they now have reports on attacks on educational institutions, medical institutions, cultural property, and most recently on the filtration system. I just got briefed by the Conflict Observatory team, and it's an incredible piece of research using 5 pieces of corroborated information under the highest standards of the Berkeley Protocol in order to establish the existence of filtration centers that are then being used to engage in deportations to Russia. Beyond this, we're also funding a number of civil society actors through our Human Rights Bureau who are engaged in documentation on a daily basis. This is undertaking great courage and determination, as you can imagine, to be doing this work. So we're hoping to help organizations organize themselves so they're not duplicating efforts, so that they're engaged in trauma-informed investigative techniques with respect to sensitive witnesses, and also so they can do so securely, and that the information that they collect will have an impact and not become spoiled by virtue of breakage in the chain of custody. On the DOJ side, I'm pleased to say that the Department of Justice is very active as well. I had the opportunity in June to travel with Attorney General Garland to the border of Poland and Ukraine, where we met with the then Prosecutor General, and he was able to announce the creation of a War Crimes Accountability Team within the Department of Justice. Eli Rosenbaum, who many of you will know, has had a storied career as a sort of Nazi hunter, and very much led that effort to find Nazis that had landed in the United States, and now is part of the Human Rights and Special Prosecutions Unit that looks at perpetrators more broadly within the United States. He has been appointed as counselor for war crimes, and as I mentioned, our Congress is looking very carefully at amendments to our war crimes statute, and ideally also enacting a crimes against humanity statute, which does not currently exist in U.S. law. So these are all underway. In terms of where U.S. policy is vis-a-vis these efforts, at the moment we're very much focused on mechanisms that are most likely going to be able to bring perpetrators to justice. And it really falls to us, just as it did to the victorious allies after World War II, to usher in a new era of accountability for the worst crimes known to humankind. And we have to work together on a multilateral basis. The importance of sustaining alliances here is incredible. Solidarity, partnership, this cannot be done by any one nation alone. We saw that in the World War II period, and we're seeing that again at an unprecedented scale at this point. There's a lot of work to be done. There are limited resources. We have recessionary and inflationary forces on the horizon that are making states very nervous about investments. There are some challenging open questions that need to be looked at by the smartest lawyers on the globe, and this can only be done in a common sense. So this gives rise to the current proposals around a standalone tribunal that would prosecute the crime of aggression as committed within Ukraine. And it's at the moment there is no court that has jurisdiction, that's ever exercised jurisdiction, or that has exercised currently jurisdiction over the crime of aggression. So this would be the first in the modern era since World War II. So a number of questions. Would the prosecution of war crimes be enough to capture the opprobrium of what has happened within Ukraine, or is there a true normative gap here that needs to be filled by this particular proposal? And we have to bear in mind the expressive function of the law and not just the retributive or restorative components of justice. What does the law need to say about what's happening in this terrible period of Ukraine's history? What legal complexities and challenges should be considered when it comes to things like immunities or getting custody over a particular accused? How to create such a tribunal? There are a number of proposals that have been floating around, and Norm entrepreneurs, including many of the people here, have really been central to generating these ideas and to sort of test driving them within fora like this. So this could be done through a multilateral treaty between, say, the United Nations and the state of Ukraine, as was done with respect to the Special Court for Sierra Leone, which we heard last evening, or potentially a regional body such as the EU or the Council of Europe. Is there a role for the General Assembly here? Is there a role for one of these regional bodies to create a tribunal standing alone of pooled jurisdiction of members of those particular organizations? The key is, of course, that the the Security Council is foreclosed because of Russia's veto. And so the way we created the original ad hoc tribunals is not available to us. There is a number of precedent for these exercises. The Special Court for Sierra Leone is one, but people often forget the extraordinary African chambers, which were convened by the African Union with Senegal to try Hissan Habre of Chad for a massive industrial size torture system that was created while he was in power. So a number of these models exist, all of which, though, will have to be adapted to the current context. There are also, of course, pragmatic considerations like funding. Would there be voluntary funds? Would the prosecutors, as I remember my boss had to do and David Crane had to do, going out constantly with hat in hand, trying to get voluntary contributions, or would this tribunal be funded through assessed contributions from the United Nations? There's also questions of whether or not this tribunal should exercise some kind of pendant jurisdiction over war crimes that are connected to acts of aggression, or would it only have jurisdiction over the crime of aggression on the assumption that war crimes would be dealt with either by the Ukrainian courts, by the ICC, or by some third state exercising some form of extraterritorial jurisdiction, including potentially universal jurisdiction. But there's also the predicate question of whether or not this is an exercise that is worth the investment of time, energy, and resources that it would need. And there is, I can say from a diplomatic perspective, no consensus yet amongst the international community. Many states are still looking at these proposals and trying to invest in existing lines of effort that can be operating immediately rather than thinking to the future about some unknown tribunal that has maybe a number of legal questions that might make it open to some sort of challenge. And so given the difficulties of getting custody over the accused, there's some question as to whether or not this tribunal is worth the effort. If it's going to be another, with all respect, Lebanon tribunal, which proceeds in absentia in some capacity, but never actually has custody over the accused themselves. All of that said, Milosevic, Taylor, and Pinochet never thought that they would see the inside of a courtroom, and they were proven wrong. It's also important, and I again say this from a diplomatic perspective, to bear in mind where the rest of the world is. Europe is very united, but there are voices and perspectives from the global south and elsewhere that have a perception that all of this energy is now going into the situation in Ukraine, and where was all of this energy when war was ravaging these other countries? There was an inconsistent and uneven response to atrocities in many parts of the world, and that has not gone unnoticed. And so some of the abstentions that we see in some of the votes before multilateral organizations, I think, reflect that ambivalence. Not necessarily an ambivalence around the imperative of justice or the Nuremberg principles, but rather where the international community puts its energies and attention and when it looks away. And as Ambassador Rapp used to constantly say, some places get justice some of the time, and we need to make sure that all places get justice when it is so desperately needed. So another gap that should be under consideration is the question of claims. We talked about this a little bit at breakfast, but there are some interesting proposals floating around about some sort of a claims commission. What would that look like? How could Russia be made to pay for the horrible damage that it has wrought within Ukraine in terms of infrastructure, loss of life, loss of property, et cetera? That needs to be considered, and there's talk about some sort of a registry where Ukrainians can start to register claims so that they can be collected, and then consideration can be made as to where assets might be available. So the question is then, how do we prioritize these proposals around an aggression tribunal given all of these other pressing needs? And I raise these questions and issues not to express any negativity, but to, as a part of a sort of critical and as I like to describe it, inquisitive neutrality. You know, I think as a government, we're really interested in seeing what the best proposals are out there, what people are thinking about this, how they're dealing with some of the questions that may arise. And the danger, of course, is always that Russia will simply wait us out. We saw this in Syria and elsewhere, and we risk seeing it in Ukraine. Time is Putin's greatest weapon. And there's an urgent need to ensure that the existing accountability mechanisms are able to actually deliver on the promise of justice for the victims, for the survivors, for the integrity of our shared, cherished values, norms and principles, for the Nuremberg history and legacy, and also, of course, for Ukraine. And so, as I said in the beginning of my remarks, I am not conveying any sort of a formal position of the U.S. government. We are examining these proposals, but we really look forward to a robust dialogue about these topics, and I will be taking these ideas back and sharing them with my colleagues across the government. And so I was asked to launch this dialogue, and it's a great honor to do so. As I said, as someone who's been here as a participant, it's lovely to be here now in this formal capacity. And so I charge you all with putting your best ideas forward, coming up with concrete proposals, and then pushing them out into the ether so that they can be discussed and shared in the halls in which power is being exercised. So thank you so much for including me and for your attention this morning. I really look forward to our conversation.